Today, Europe is quietly changing the way it treats statelessness, not through a dramatic political speech, not through a revolutionary new court, but through something far more important, a procedural shift. For decades, European migration systems operated on one silent assumption: every person belongs to a state somewhere. And once that assumption collapses, the entire legal structure begins to malfunction. That is exactly what statelessness exposes. People trapped between legal systems, children born without effective nationality, families caught between incompatible civil status rules, individuals who cannot be deported because no country will legally recognize them. For years, these cases were treated as administrative anomalies. Now, slowly, Europe is beginning to realize they are not anomalies at all. They are structural weaknesses inside the modern legal system itself. The newest developments in European law show this very clearly. The implementation phase of the EU Pact on Migration and Asylum is now moving toward operational reality, and for the first time, European authorities are expected to identify indicators of statelessness already during screening and registration procedures. This may sound technical, but legally it changes everything. Because historically, many stateless people disappeared inside migration systems until very late in the process. Authorities would process asylum claims, initiate deportation procedures, even place people in detention, only to discover later that no state could actually receive them. The result: administrative paralysis, endless limbo, failed removals, and sometimes detention without realistic prospect of deportation. Europe is finally beginning to understand. Statelessness is not only a humanitarian issue, it is a procedural problem, and if the system fails to identify it early, every later stage becomes unstable. Germany is now becoming one of the key testing grounds for this new approach. In April 2026, Germany introduced its GEAS-Adaptation Law, reshaping asylum and return procedures under the new European framework. But the real question is not whether Germany can process cases efficiently. The real question is, can the system distinguish between undocumented persons, unresolved nationality cases, and genuinely stateless individuals? Because these are not the same thing, and yet many administrative systems still treat them almost identically. This becomes especially dangerous once detention or return procedures begin. A return system built on the assumption that every person belongs somewhere eventually reaches a legal dead end when confronted with statelessness. And this is where highly rigid legal systems begin to struggle, not because there is no law, but because too many legal systems collide at the same time: nationality law, migration law, family law, civil status law, foreign administrative systems, international documentation standards. Modern statelessness cases often involve all of them simultaneously. At the same time, Greece is moving partly in the opposite direction. Its 2026 migration reforms strengthen criminalization of irregular stay, restrictions affecting NGOs, and stricter migration enforcement mechanisms. And this creates a serious danger for stateless persons, because stateless people often already lack recognized documentation, access to consular protection, or stable legal identity records. When systems respond primarily through criminalization, the exclusion becomes self-perpetuating. One recent parliamentary concern in Europe exposed this contradiction clearly. Stateless persons were reportedly excluded from parts of a regularization process because they could not satisfy nationality-based documentation requirements. Think carefully about that. The very people most in need of regularization may become excluded precisely because they are stateless. This is not simply a bureaucratic issue anymore. It is a structural contradiction inside the legal system itself. At European court level, another major development is unfolding. The ongoing Shamima Begum case before the European Court of Human Rights may become one of the defining nationality rights cases of this decade. Many people see it only as a terrorism case, but legally, the deeper issue is much broader. Can states reduce their human rights responsibilities by depriving individuals of nationality? This touches directly upon effective statelessness, procedural fairness, and state responsibility. Because in reality, a person may possess a nationality on paper while having no practical access to protection, documentation, or rights. And this idea, effective statelessness, is becoming increasingly important across Europe. The law is slowly moving away from asking, does nationality formally exist, toward asking, does nationality actually function in reality? That is a profound legal shift. Another major development came quietly from the Council of Europe. The CDCJ Compendium on Access to Nationality for Stateless Children may become one of the most practically important soft law instruments in Europe. Its significance is not symbolic. It creates a comparative framework of safeguards aimed at preventing childhood statelessness, and this matters enormously because child statelessness exposes some of the deepest failures of procedural coordination inside Europe. Children born in Europe can still become trapped between incompatible nationality laws, conflicting civil status systems, delayed court executions, missing documents, and fragmented institutional responsibilities. One institution recognizes the child, another questions the identity, a third demands impossible documentation, and no authority possesses competence broad enough to solve the entire situation holistically. This is where legal systems reveal their limits. The deeper problem Europe is beginning to discover is this: statelessness is not merely about lacking nationality. It is about what happens when legal systems themselves create procedural dead ends. And this is why statelessness matters far beyond migration law. It is a stress test for the modern administrative state itself. It exposes fragmentation, rigidity, procedural incompatibility, and the inability of institutions to manage exceptional cross-border realities. Europe is finally starting to detect statelessness earlier. That is progress. But detection alone will never solve the problem, because the deeper question remains unanswered. Can modern legal systems adapt once they encounter cases that do not fit the assumptions upon which those systems were built? And that question may define the next decade of European migration and nationality law.